issue of the manifest bias.
Okay.
My Lord, Exhibit B.
Yes.
But no exhibit attached. The exhibit does not even arrive. But my Lord said we had offended the rule.
Okay.
2. Now, a clear 3 year. That one we attach a it's a certificate attached. But he says he is applying the ruling mutatis mutandis. I want to bring to your attention the decision of this court in the report versus High Court Bogatanga. The 2001 Supreme Court of Ghana law 53, sorry. The Supreme Court to quash the orders of the High Court. Hawa Yakubu had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said to be, and all the orders High Court in Boga were quashed. And the resulting effect that all the consequential orders having been founded, this filed by a commission. The application was heard. No rights which justice. My Lord, because the judicial review, which had the video recordings of those declarations, was duly served on the respondent. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. They stood up and opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. There is a new. And that is exactly the decision of the Supreme Court in ex parte Hawa Yakubu. My Lord, at this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission deposed to by Mr. Samuel Tete be expunged from the records of this court.
Why?
These are matters that are his personal knowledge. He is not the returning officer of any of the constituencies named.
This affidavit by not
any official record document to the deposition or a report by any of the returning officers detailing.
Yes. I don't think we.
No, I just want to bring it to your position. Should not.
Oh no, we said that. The back to his information. It doesn't actually establish a fact. That is a different matter.
Yeah.
But you can't. Don't say we should expunge it.
My Lord,
Yeah.
the respondents say they had already done the collation. The point you consider, my Lord, the morning of that Friday, with the greatest respect, that appeared at General Jurisdiction 6, my learned senior Justin Amenufo and Gary Nimako, where there was a pending injunction application against the Electoral Commission. That it, my Lord,
my Lord, so far, various allegations have been made in this court in the course of his submissions. Deposed. I hope that when he gets my to give alternative facts, because he's been going on and on and on.
No, counsel. If he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the So anytime he's going affidavit, draw our attention. Yes, counsel.
Mr. Tam,
We have a.
please restrict yourself.
Go. Yeah.
yes, my Lord. So,
We don't
my
have
Lord,
the whole
no,
day.
my Lord, our response is that at all material time, an injunction application that we had all appeared before the judge and gave us Tuesday.
My Lord, this
So you haven't deposed. You haven't
it
deposed.
is not in your.
Deposed to it. So let's go on to another point.
My Lord,
You were addressing us on the what you said is the argument that
Yes.
the declaration has been done already. So address
my
us
Lord,
on
our quick response is that, in fact, in the Hawa Yakubu decision, orders were made, and those orders were even complied with. But when it was brought to the attention of the Supreme Court that there was a fundamental breach of the rules of natural justice, the decision and all the consequential orders founded on it were all set aside. My Lord, it is on this that we make this prayer. Yeah, so, my Lord, it's on this basis that we invite this honorable court we urge on this honorable court to quash the orders of the High Court General Jurisdiction 13, my Lord, maybe just a quick point. In paragraph, with respect, in paragraph 10 of the second to seventh interested party affidavit in opposition, particularly paragraph 10, it is the fact that our agenda was heard.
What? Okay.
Our was heard. Dismiss. Yes. My Lord, with the greatest respect, the gender application was treated in a very cavalier manner. In fact, it was not moved.
That's the problem I'm complaining about. What you are alleging
Is that
joinder was heard? A joinder which was on the docket, how can it be heard?
No, I think there are cases that you were hearing.
Yeah, that's what I'm saying.
So it's different from saying that
we're not heard. Nowhere in my Lord's ruling did he hear say, with respect, that he heard our judgment and dismissed it. Nowhere. In fact, he himself said he will not allow the joinder hearing of that. How can that same joinder be deemed to have been heard?
no, he said you a hearing on the application.
Yes, my Lord, and that is why we are.
So it's not the joiner. He had before him an application for mandamus. And there are cases that when you appeared, he heard you on the application for mandamus.
No, my Lord.
No, I'm trying to get you to understand their case. Oh, you are misrepresenting their case.
What we are making is that we were never heard on the application for mandamus.
Mr. Tomekulu,
Saying that will be heard.
Mr. Tomekulu, I'm reading something from Nana Akua Owusu, a 3 years exhibit. I think it's the first one.
My Lord, 1 minute.
Yes, I have it as A series. The one in respect of Nana Akua Owusu, a 3 years.
Well, Lord, I want to just locate my.
I believe it's new.
No. Okay. Yes,
You found that?
yes. Is it the mandamus application?
Yes, the ruling, yes.
And the ruling attached it to our supplement. That's the B series.
Yes, I have it as A series, but it's fine. But the one in respect of Nana Akua Owusu, a 3 year.
Yes.
Have you seen the ruling?
Yes.
Please read the first of that ruling. Whether or not you were heard.
So,
Can you read it?
on the face of it, it's not different. And notwithstanding the submission of a friend of the in the person of Godwin Kuju Edwiji Tamaklo to the effect that the winner of this constituency has been declared. And he proceeds, which no evidence is before the court, except yet to be moved.
Yes. So you made a submission.
The submission is to do of the pending joinder and the judicial review. Notwithstanding bring notice. A friend of the court that was not counsel for a party.
No, but you were not party to the. Perhaps that was why he decided to grab you as such. Yes.
No, my lord, you see record of me being a Oh, my lord, just to draw his attention.
Anyway, we still have two other parties.
So, my lord,
you
so,
wind up,
my lord,
wind up.
on this basis, so, my lord, this court has on many occasions upheld the fact that the person affected Lord, within this context, to do that will be a serious affront. That affront to the rule of law, constitutional requirements, and the rights to head the other party. The Supreme Court, and my lord, I conclude here, the Republic versus Court of Appeal, Anthony Tomford, ex parte Ghana Chartered Institution of Bankers, 2011, 2 SGLR, page 941. The Supreme Court, speaking through His Lordship Justice Atibuba, held that the terms of Article 296 are mandatory and obviously require the observance of the rules of natural justice, especially the ordinary rule involved. Ordinary anterior party rule has been elevated to constitutional pedestal, and this breach has constitutional consequences. My lord, and said breaches void the act in question. My lord, it's on this note that I draw the attention of this honorable court with respect to grant the application as prayed.
All right, thank you. Mr. Justin, counsel for the first.
Yes, my lords. My lords, we are opposed to this on our affidavit in opposition and the statement in support of that affidavit in opposition. My lords, except to add that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, a single one of them, has deposed to an affidavit in this court telling the court what injury they have suffered by General Decision 13, they're saying that Electoral Commission, go and perform and complete your constitutional duty. None.
Oh, you mean the?
Yes, my lords. There's nothing.
How about
my lord? The first applicant is not a party who has stood for election and for which he is claiming that he has an interest. It's an artificial person. These are individuals. The first go to parliament. It are individuals. Well, he said he has sponsored. Let the sponsorees, it's the sponsorees who go into parliament, not my lord. Of both number J4 dated 9th March 2016. Suit number J4/5/24. It's a judgment in which my Lord presiding and his brother Justice Badegbe delivered the ruling, and their ruling touched on the of Rule 1. Order, my Lord, which is 4 Rule 5.1. And kind permission, if I may read. Of CI 47. No proceedings shall be defeated by reason or non-joint, and the court may in any proceedings determine the issue in dispute so far as of the person proceedings. My Lord, even if we one of appeal. So far in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore Cesurera should lie. Respectfully submitted. Thank you.
Oh. You argued Howard Yakubu in your. You argued Howard Yakubu.
Yes, my Lord, I did.
And Howard Yakubu, the decision was that if the party in an election will be affected.
No. My Lord, the order in Howard Yakubu was directed at her, an injunction placed. But in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder, but you can question it on other parties.
Yes, my Lord.
As happened in Howard Yakubu.
Yes.
And I read your submission where you try to distinguish Howard Yakubu.
Yes, my Lord. And then also, one last thing, now that you have brought it up, my Lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my Lord will look at it as an application. My Lord, there is an application because of the way the numbering is manual. I'm not able to. It is an application. Let me give you.
Counsel, take your time.
Counsel. My Lord, it's an application filed. Oh, my Lord. Well, my Lord, this is the application dated 16th. It was filed on the 16th of December 2024. My learned friend made reference to it. But in that particular matter, he hasn't brought the ruling of the court. There is a ruling of the court on that particular application. So, my Lord, to wrap up, none of the applicants before the court have made. Yes, thank you. I'm most grateful.
Okay. Thank you very much for saving our time.
I like the word mania.
Yes, Mr. Nimaku.
My lords, we are also opposed to this application. We filed a political position in the statement of case on the 25th of December 2024. We rely on all the depositions made in the affidavit and the exhibits attached. And the authorities listed in the statement of case. My lords, my other friend has hinged this application on a motion for joinder, which was not the docket of the court, which all parties to the action were not served with the said application at the time when we were dealing with the mandamus application. My lord, we submit. The application for joinder was indeed a non-starter. That is because, my lords, there are specific rules dealing with mandamus application under CR 47. Specific rules. Joinder is not one of them, one of those. And my lords, in Boifio, this is NTS for properties. Boifio, this NTS for properties, 1996, 97, held. That the law was clear that where an enactment had prescribed a special procedure by which something was to be done, it was that procedure alone that was to be followed. My lords, Order 55, Rule 5.2 has provided for the procedure by which notice of an appeal for judicial review can be communicated by the court to any affected party. That procedure is not joint application. I was from a court, the 4.5.2. The court may order that notice, and it is may order that notice of the application shall be served on any person not named as being directly affected by the application, if in its opinion, an opinion at the line, it is desirable that a person should be given notice. There is a rule, my lord. There is a rule, not by joint application. And my lord, this is a discretion which a court has to exercise. It's a discretion. It's a discretion. And if a court exercises discretion, whether rightfully or wrongfully, the aggrieved party, if so minded, cannot come by judicial review. The nation should arrive.
What is your authority for that?
My lords, if I may refer this honorable court to page 3 of my single case. Page 3. Republic versus Court of Appeal, as per the Jurisdictional 2005-2006.
Oh, read the report.
Read the report. Very well.
If you have the report there.
Yes, yeah. The clear thinking of this court is that.
What page are you quoting?
About page 619. 619.
Yes.
The clear thinking of this court is that our supervisory jurisdiction and Article 132 of the Constitution should be exercised only, and the word underlined only, in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to the jurisdiction or are so plain as to make the jurisdiction a complete nullity. My lord, if I may even look, if you may
now, I get the point, but you see, you would agree that the ex parte Chachuchikata case and the ground that was being discussed by Georgina Wood, JSC as she then was the ground of error of law. Let's pay attention to the fact that they also have a ground of failure to observe the odi alteram pattern. So, yes, if it comes to error of law, your point holds. But also address the area of the failure to observe the odi alteram pattern rule.
Yes.
You have argued it, but I think you should expatiate on it.
My lord, we submit that a non-party to a suit cannot complain that his right to fair hearing has been breached. In this case, my lord, I said Republic versus High Court, Accra. High Court, Accra. Ex parte, Danso, and others. MPP, EC, interested parties. 2015, 2016, 1 LGLR at page 760. 760. 1 Supreme Court of Ghana Law report at page 760. Holding 1. This court held in dismissing application for judicial review as follows. That in respect of the first ground by the applicant alleging breach of the right to fair hearing being a fundamental right that is available to parties to an action, this court is unable to extend its scope to persons who have not, on the record, yet become parties strictly so as to speak. My lords,
but there are several decisions. Republic versus Colleague Magistrate, ex parte Amponsa, which has been cited by Amenuvo. They said that as for certiorari, their public law reliefs, you don't have to be a party. And then we have.
My lords, this is about capacity. It is an order.
No, I just want to say that the general blanket statement may not be true because there are alternative authorities. If in this case you want to make a distinction, fine, but judicial review is a public law relief, a non-party can come for it. Experts at the Valley and so many other cases.
Yes,
but make your point.
Yes, so the point we are making is very simple. The High Court only made an order directed at a public body to perform public function. To simply go and collate and declare a winner of a public elections. And my Lord, I believe that all of us here are interested in who is the winner or a loser in our elections. So that order, which the court made for the EC, the first to go and collate and declare who has won or who has lost, my Lord, it's a public function. It's a public function. How does that order to go and collate and declare the winner or a loser of our elections affect somebody injuriously?
Oh, look at your Exhibit 9. Look at your Exhibit 9. D9. Your Exhibit D9.
Yeah, my Lord, Exhibit D9.
Yeah, D9 is supposed to be, I don't know what I would call it, the collation sheet.
Yeah, it's a public document.
It's a collation sheet.
Which is a parliamentary election results summary sheet.
Yeah, now look at the last part. You know, that form has got the various candidates.
Yes.
And the marks or votes that they scored, right?
Yes.
Now look at the lower part, where provision is made for the candidates to sign or refuse to sign. Because the refusal to sign means that a candidate may disagree with the coalition and would want to raise an objection. That is considered and entertained by the Electoral Commission themselves. So how do you say that the order to collate doesn't affect third parties?
My Lord, you don't respect.
Because they have a right even at the administrative level to object.
Yes, my Lord, under the CI 127.
Yes.
If a party decides not to participate in the process,
Yes.
it doesn't stop the EC from performing their function.
Yeah, but what we have here in your Exhibit D9 is the sheet which has only the MPP parliamentary candidate's name, his agent, and his signature. There's nothing about all the others. There is no reason why they did not sign. So the point I'm trying to make is that even the form of the Electoral Commission entertains the fact that in the coalition, the other contestants will have an interest.
My Lord, with all respect to you, in the bench, this document, D9 that you are referring to, this becomes relevant when the results are gazetted and you want to challenge the result of an election petition. Petition. My Lord, with respect. At the time when the court was making an order for Madam's application, this exercise I don't be effective. But now, personally,
I'm just trying to say that what the applicants are saying is that they still to be affected, and you are saying that they would not be affected. Electoral Commission is saying that they will be affected. That's why they have this form, which makes provision for them, for all the other candidates. So the Electoral Commission, Mr. Menubo, you can also comment on it. Because you didn't exhibit it, I didn't want to spring it on you, but it was exhibited by the 2nd to 7th interested parties.
Yes.
Yeah.
So my Lord, I mean, this particular exhibit D6, 7, 8, and 9 is contained therein were not factored in.
Okay. All right.
At the time when the court making an order that proceed to go and do collation and declaration.
Okay. Agreed. Mr. Menebo, if you that's right. No, just one point. Mr. Menebo, if you have those exhibits, I think you should check them well, because D10, the form there is a bit different. So it will be of interest to you. You know, the D10, the form doesn't contain the portion for stating the reason why you will
yes,
not.
My Lord. I
so it's of interest to you.
Yes, my Lord.
Okay, thank you. Yeah, Mr. Gary.
Yes, my Lord. So, my Lord, clearly, the point I'm making is that if there's public elections have been conducted in all polling centers, result declared in all polling centers, what is left is collation and declaration, summation of the various results in the various polling stations. Why should it be a problem, my Lord? Why should it be a problem? Why should it, we don't why should the EC not be allowed to do his work? So, my Lord, the point that we are making, granted without even admitting that the application for joinder, which we have said, my Lord, is a non-starter, because the rules don't provide for joinder applications. If the judge has been aired, granted without admitting that the judge has been aired, the recourse of the petition of the applicant is appeal, not judicial review. And the judge should arrive, as you have to do before you this morning. My Lords, again, my little friend make a point about where's the rules book? About we not filing a statement of case. Thereby making the application not right for hearing, and the judge being biased. We refer my Lords to Order 55, Rule 6, Two, 3, of CI 47. That within 14 days after filing this application, the applicant shall file such copies of the case as the registrar shall determine, setting out fully arguments, relevant cases he wishes the court to consider. My Lord, is the registrar. Now, if the applicant does not file a single case within a time stipulated under Sub 2, the registrar shall certify that fact to the court, which may dismiss the application for non-prosecution or make such other order as it may consider appropriate. There is nowhere, my Lord, that the non-filing of the statement of case deprive the court of jurisdiction to detain the application that was before it, to the extent that the registrar or the court, which was supposed, if it was desired to do so, made no such order. In any event, my Lord, the respondent, that is the EC, that was supposed to go and carry out its constitutional and statutory duties, they did not put application. They took the view that yes, they wanted to go and do their work. And indeed, my Lord, they have gone to do their work, declare the winner, declare the loser, and the matter is foreclosed. Oh, foreclosed.
If that were the law, the illegality will persist forever.
My Lord.
So I'd like your other arguments, but as for foreclose,
my Lord,
your other arguments you have answered substantive.
My Lord,
yeah.
My Lord, an order by a court to proceed to perform a constitutional essential function.
If it's set aside, that will be the consequences are clear in the authorities. Anyway,
with respect.
Yeah. Your other points I will take, but as for this one,
yes.
Yeah.
Further, my lords, it is not the applicants that were going to perform the said constitutional duty. Not the applicants. It's the first interested party. So granted, which I already indicated that the joint application was not funded by the rules. Granted, they will not have been a necessary party to the action. Granted, because the application was directed at a specific body, the EC, and no one else.
Now let me pick your mind on something the trial judge said in the ruling in respect of the application by Nana Ekwia Owusu Afriye. If one of your assistants can open to that. The ruling in respect of the application by Nana Ekwia Owusu. Yeah, be serious. Now, if you can read the whole of paragraph 1 and it extends to the next page, read it and.
Paragraph 1.
Yes.
As we be serious, the application on the face of it is not different, notwithstanding the submission of a friend of the court in the person of Godwin Edugi Kujo Tamaklu, to the effect that the winner of this constituency has been declared, and which has no evidence, is before this court, except an application yet to be moved. It is observation of this court that the respondent will not be affected if indeed it has been declared already.
Now you stop.
As it stands.
No, just now you stop there. You see, this conditional, if it has been declared already, where does it leave us? Because the applicants are contending that it was declared already. And then she's saying that if it has been declared already, then this ruling doesn't change. I'm finding it difficult.
Alos. Alos.
Yeah, you were there, so probably you.
Yes, alos. The application, my friend, far before you. If you look at all the exhibits which they have filed, my lord should realize, what is all this? My lord should realize that they have not, or they did not, what is this? They did not, no, our application, our affidavit, yes, they did not attach any parliamentary election results summary sheet to demonstrate that, in fact and indeed.
Oh, that, we hadn't reached that stage. Because
then direct me properly.
No, the point I'm making is that the judge is saying that if there had been a declaration already, then the person whom it was first declared for would not be affected by this ruling. But that is a very risky, slippery ground.
My lord, the bottom line is that, let's say, even there was even a declaration, in quote, but there was none, in quote. If the collation is done and you won, it will be confirmed that indeed you have won.
No. The judge said it will not affect her.
No.
Anyway, It is not your writing. It's because you were there, that's why I wanted you to react.
There is no way that if you win an election, and you have won an election, the results will change. If you have won, you have won. If you have lost, you have lost.
Anyway, that is the dispute. The dispute is whether the first person won or the second person. So that's the dispute. But I must be honest with you that the application before us, we are not in a position to resolve the factual dispute.
That is true.
As to whether the person who was first declared or the person who was second declared. We are not in a position to resolve that dispute. Ours is to look at the legality of the proceedings that resulted in the order for the Electoral Commission.
Yes.
Yeah, so wind up and then...
So my lords, in conclusion, I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record, which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that the High Court judge exercise a discretion. If the applicants are agreed about the discretion so exercised by the High Court judge, their remedy lies in an appeal. And not this forum. My lords, we submit accordingly.
Thank you.
My lord, just a quick, okay. My lord, with your leave, just one point of law. My learned friend in his concluding statement says, our remedy lies in appeal. My lord, with the greatest respect, without being joined and being a party, we could not exercise the right to appeal.
I have authority to give him. I have authority to give him to go to an appeal. Is it there? And I will give it to him. Yes. 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 The authority is there, I'll give it to him.
The court will take a short break. All rise.